Welcome to today's webinar on SEBI compliance for RIAs, impact and implications. I'm Dipali Lalwani, and I'd like to quickly introduce our expert panelists for today. Our host for this discussion is Eric Horn. Eric is the Managing Director of iFast Financial India Private Limited and a Director on the board of iFast India Holdings Pte Limited, Singapore. Eric joined the iFast Group in 2004 and was instrumental in creating Singapore's very first end-to-end software for financial advisors, giving him a deep expertise in designing systems that address every aspect of an advisor's business. Our next panelist is Rajesh Krishnamurthy, Country Head, India Liaison Office with the Financial Planning and Standards Board Limited. Rajesh has over 20 years of experience in the financial services industry and was the founding managing director of the iFast Group's India business. Rajesh is also a part of the National Institute of Securities Markets Investment Advisor and Retirement Advisor examination committees and has served on SEBI's working committee and group that works towards developing and updating the investment advisor regulations in India. Our audit and compliance expert this evening is Mohnish Vadhva, Chartered Accountant and Managing Partner at Vadhva and Shah. Mohnish gained his regulatory experience at KPMG and Deloitte before founding his own firm focused on the investment advisory practice. Mohnish has been a consulting auditor to RIAs since 2015 and offers guidance on various aspects, including regulations, compliance, and setup of policies and procedures. Mohnish is also a specialist in the compliance norms relating to PMS and AIF offerings. Good evening and welcome, gentlemen, to the panel. Before I hand over to you, just one important announcement for our viewers. We will be accepting questions for the panelists through the chat box. So if there's anything you would like our panel to talk about, please do type it into the chat box. And in the later half of the session, time permitting, our panelists will address it one by one. Well, that's it from me. Over to you guys, and wishing you all a very informative discussion.
Thank you.
Thank you, Dipali, for this great introduction. Right, I'm very honored to be on this panel with two experts here who have been looking at the regulations for a long time. And of course, Rajesh needs no introduction. He was part of the SEBI working group that came out with the RIA regulations. Right. So I think we are looking at a webinar first that I wanted to express our views here, actually based on the general basis. Right, so it's based on our understanding, right, of the RIA regulations and the spirit of the law. Right, so we recommend that you, of course, seek a professional legal advice to take your decisions. Right, so we'll be discussing on the various points that has come out in the changes and the informal guidance. Right, without much further ado, I think I will start off with the changes that has happened, I think, since last year, and I know of many advisors who have been very busy, right, in trying to meet the new regulations. Right, I think the last 6 to 9 months, the feedback from many of them is that they've been spending time really to understand the regulations, to also know how to move forward their business, right? And recently we actually got, of course, the latest changes came about with the BASL, which is the BSE body that is being appointed by SEBI, all right, to actually do the supervision and the regulation of the RIAs, right? So with this change, my first question would be to Mohnish. What do you think will be the audit like for the RIAs going forward?
So thank you for the question, Eric. See, before even we go there, before even we start with BASL, let us just first talk about why was it required to get BASL. So SEBI, as we all know, has a lot of work. They already have a lot of regulations which they look after. There are a lot of entities already which have to comply with SEBI regulations like PMS, AIFs. RIA being one of the most important regulations which came in quite lately in 2013, after which we've seen that SEBI has not been able to cope up with the, you can say, day-to-day requirements, and a lot of applications were getting delayed, a lot of queries were being raised by a lot of stakeholders. So that is where SEBI felt it was a requirement of the hour to have somebody, another regulator in place who can actually have a closer view and a closer look and a closer hold on all the RIs, and that is the reason why they came up with this BASL. Two aspects here, one from the RIA perspective and second from the auditor's perspective. Of course, we've seen it historically that whenever there has been a new regulator, a specific sub-regulator or a regulator who has come in to monitor a specific set of people, then the level of scrutiny and the intervals of scrutinies have increased. Of course, after BASL, so of course they will take some time to set up their procedures and get in action. But once they are in action, we are expecting that the level of scrutinies will increase, which SEBI is actually taking very seriously, because they have been quite serious with a lot of client-related concerns, customer-related concerns. So from an auditor's perspective, when we know as an auditor, as whenever if I'm vouching or if I'm reviewing anybody's file, any RIA's file, from an auditor's perspective, I will myself be very cautious, because I'm aware there's a full-time monitoring authority who is monitoring the RIAs, and there is a dependence. The dependence on auditors have increased. So that way, our scrutiny level, our review level, and the level of our queries also would increase. We have already started reviewing our old files and already started reviewing our SOPs, which are there in place for the purpose of audit, so that we can capture a much wider view and try to get our documentations in such shape and manner, so that even if BASL tomorrow is raising any queries to any of our clients, or for that matter to any of us, we are in a position to substantiate those queries.
Okay, great. So, I mean, with Rajesh, of course, he has been working in the working group for some time. What are your views on these changes?
Thanks, Eric, for having me here. Always a pleasure. Thanks, Manish, for kicking off on the most important development since probably the last many months.
Yeah.
I think, as Manish said, one of the key things that we have to note is that now there are two levels when it comes to looking at RIAs. And therefore, what happens is BASL becomes the first level from a regulatory perspective. However, I always say that there is always going to be four levels. One is, knowing that there are two levels above you, you have your corporate governance, which is your most important level as an RIA. And before that, the fourth that I say is the customer facing one, which is every person who is interacting with the customer, what kind of standards, ethics, customer focused conversations you have. So that kind of starts the whole chain. And so while that always existed, corporate governance always existed, SEBI always existed, what has come in the middle as a third layer is BASL. What is interesting to also note is that the very name of the separate entity that has been created by BSE is called BSE Administration and Supervision. And so the operating words are there in the name. So there is a regulation, then there is an administration of the regulation, there is also a supervision of the intermediaries. So a lot of work, I guess, that are administrative in nature from a regulatory perspective, I think would naturally flow in now into BASL, because that is what the regulator would expect BASL to do. And then from a supervision point of view, there would be many matters which probably would be highlighted as areas of supervision. Like usually we have certain risk-based supervision, say, for example, intermediaries who are stockbrokers, for example, you have risk-based supervision. Similarly, you have risk-based supervision for RIAs too, right? So the risk-based supervision may now start, the supervision aspect may start flowing in from BASL. And I would believe that since it's an exchange, it's already been, in a way, familiar with regulating many participants. The scalability of such supervision is also going to be high. So when you have a system that is scalable, you should also normally expect that the participants also would be expected to scale up with the scalability of the system.
Yeah.
That's actually a very good point. And also, is there a reason also why the exchange is appointed for this job? Because of the experience, in doing the audit job for the stockbrokers.
Yeah, actually, that's also just to add on a good point that you brought in, Eric, because many people would think, what does an exchange have to do with investment advice? Because investment advice is a lot more than that. But I think in every such direction, what we also need to understand is that an exchange is here to facilitate certain functions. It is not necessary, and therefore you see that the exchange is not the regulator. And it is neither an organization that is trying to tell you what should be the regulatory aspects of your profession. That's not what the exchange is expected to do. SEBI is clearly holding on to that power. So I think in a way what we all have to understand is that in every exchange you could also have members who are limited purpose members, and I would say a stockbroker is a full-fledged member of the exchange. But an investment advisor operating with BASL is more like a limited purpose member from an exchange perspective. Although now we are talking about BASL, so it's a separate entity. So I think that is not the point to look at in a way for the entire fraternity. We just have to understand that it's a system that is being put in place. And I have some pointers on that as we go ahead in the conversation. And we have to see it as an infrastructure that is there to help scale everybody. Supervision is only in the interest of the profession, and I would say interest of the consumer and interest of the profession. So that's how I would look at it.
That's a very good point. I also agree. I think that in terms of the experience of the advisors in the last, I think 6 to 9 months, right, when some of the audit has happened, we can also see that there's an increase in the scrutiny, right, and it looks like it will get more stringent going forward as well. And I think if we were to look at it from this perspective, and an auditor who is experienced and competent will actually become even more important, right? We have seen also, like in the case of stockbrokers who are being fined, and some stockbrokers who have also lost the license, right? Munish, so on this basis, do you think this could also happen in future now that the audit and the revenue is going to get more stringent?
So I would not want to scare people who have actually taken interest in coming in looking at this. But yeah, see, you have to see from an Indian regulator's mentality perspective, what matters the most. Yeah, of course, that could be one of the start points, as you said, non-maintenance of books and non-maintenance of records. But what matters the most from an Indian judiciary's perspective is the intent, whether there was an intent of there being a wrongdoing involved here. So, of course, if the intent is wrong, of course, then in that case, that would lead to losing your membership. But in case of ignoring the requirements of the regulator and ignoring the requirements of BASL, they're of course going to come up with their bylaws. There'll be a lot of changes, and we will see. So this is just a beginning. So we will see on day-to-day basis, there'll be a lot of new things that will be introduced. The responsibilities will increase. If those are not taken care in the course of advising and in the course of taking care of their roles and responsibilities, then we can expect huge penalties being imposed by SEBI. And regulators, they usually don't give you a menu card of all the penalties, like what would be the penalty for this offense, what would be the, it is to their discretion. They discuss, they decide, they interact, they interrogate with you, and then they come to a conclusion that this would be a penalty, and it can be ranging from smallest to largest. So one should keep that in mind instead of having that situation where your entire business comes on a standstill and you get involved in the entire regulation day in, day out, just dealing with those queries coming into your desk. It's better to be compliant, and we come on track and move out from those traditional way of carrying out our RIA activities.
Right, right. So, I will just stay on this point in terms of the audit. And I think you have been doing this audit for many years. What have been some of the common observations that you have seen, right? And also that you feel should be improved in order for the RIAs to be compliant?
Yeah, that's actually a very nice question, Eric. So in the course of audit, which we usually see, so as I earlier mentioned to you in this last discussion which we are having, that we have observed that RIAs are yet into that traditional way of functioning. They have not come out of that mode, especially the individual RIAs. So they still follow. A lot of RIAs have that tendency of just picking up a call and advising their clients and just telling this is a new script, this is something which would match to your requirements, and you can actually look at some sort of, so they do their level of homework, of course. But what is the most important thing they try to miss out here is documenting it. So what the regulator now wants you to have an end-to-end documentation, like right from the time when you are referred to a client till the time you actually understand the risk assessment or a suitability assessment of a particular client, till going further down till the time you actually give a particular suggestion to a client of a particular script. So end-to-end documentation is something which is most considered as most important in today's date. In our fraternity of chartered accountants, we have this statement which we usually say: work not documented is work not done. So if you don't document a work, the regulators will consider that you have not done that work at all, which is most important. And when I talk about this, I actually recall that 80% of the times I see that when we go to check the logs and when we go to verify the transactions of each RIAs, how they're placed, what are the documents in place, I see that the rationales behind placing a particular deal is always missing. Or they just write for the sake of mentioning they're approved, or client is okay with it. So they don't expect, the regulators are expecting you to maintain proper rationale, that how did you conclude that this particular product is important for that client of yours. So these are a very few things which are small. Those are not very cumbersome to maintain, but these are very important. And we've seen in our practical experience, when SEBI actually knocks your doors, they get to vouch your transaction. What they actually do is, they, out of a population of say 10,000 line items, they would just randomly select 50, 100 line items, and they would ask you for the rationale, they'll ask you for the documentation. Though in good faith you have actually picked up a call, advised the client, but at that point in time you will not have answers to give to the SEBI. So and that gets recorded immediately. It gets minuted by SEBI immediately that has not been maintained. So my personal advice or my personal view would be end-to-end documentation is something which RIAs should look at, and that will keep auditors happy, that will keep SEBI happy, and eventually it will keep you happy.
Right, right. And Rajesh, do you have anything to add on this?
No, I guess, Manish is working in the trenches, so no better person to share that. But I guess, one addition that I would probably make is one of the key things that has come in the context of BASL is that if you noticed, there is an inclusion of arbitration in the amendment that has been made. And that's something that we should all make note of, because arbitration mechanism then flows into the BASL um, arbitration mechanism now. Because earlier the regulation mentioned that, RAs under the regulation, there is an arbitration, but the investment advisors were told that it will be as per what is, specified. And then now with BASL now goes on to specify arbitration. It comes with two things, I guess, from an audit point of view and the aftermath of it, in the sense that maybe from an audit point of view, what Munish mentioned is sacrosanct. But from a consumer point of view, because many a time when there is an observation in audit, it can also possibly have affected the consumer on the other side, or the client, as you call it. So if the client is affected, then the client is now able to invoke arbitration. And therefore, if you permit me and if you have time, probably I could spend 2 minutes just sharing that.
Sure.
As of now, under BASL, they have not provided the panel of arbitrators, but if you go into BSC website, you have while the mechanism document is there to be downloaded under the BASL website, but just to get a sense of what it could be, you could refer back to the BSC website, which has the arbitration pages and the panel for arbitrators. What is interesting for all of us is that now we have one more stakeholder to manage, which is the arbitrator residing in probably at least the city that you are operating in. Because from the panel of arbitrators, a consumer can actually end up choosing any three, and telling that, this Mr. ABC from this city, you got to represent me as an arbitrator. And many a time, if it is so, the mechanism in BSC is that if the claim is less than 25 lakhs, then only one arbitrator needs to be appointed. If it is greater than 25 lakhs, then both parties have to come forward and say, who is going to be my arbitrator? And then these two arbitrators would discuss amongst themselves, and then they will appoint one more who would chair or preside over the whole arbitration, which is basically, I represent the client, here is the gentleman or lady who's going to represent the investment advisor, and then the two of them will discuss and say, okay, let's have a chair. So this person is consensus basis, both of them agree, okay, there is this third person. So what it means is that arbitration is a reality if there is customer grievance. I mean, we are talking about only if there is a grievance, right? And the second part to it is that it is also a good thing, because from a conceptual point of view, the expectation is that you complete issues within 4 months. That's what has been said. So you are likely to have a system, if it functions very well, wherein any grievance will get sorted out in 4 months' time. And then they have given a provision that in stray cases, if there is a requirement, we could give a 2-month extension, which means within 6 months, if there is a problem between a client and an RIA, you could expect a solution. That doesn't stop the consumer from saying that, I want to set aside this arbitration because something has not been taken care of. I don't want to. And then they can, pursue this further with maybe a court of law like High Court in Mumbai. And I think the section there, I think I just have to refer to be very sure about it. Yeah, section 34 of the Arbitration and Conciliation Act 96. So these are things that get added to your checklist of internal compliances and, stakeholders from a RA perspective. Because, I don't think we ever experience arbitration as a necessary, checklist when we were looking at our preparedness for ongoing compliances should something go wrong. So I just wanted to throw that perspective as well.
Sure. Thank you. Yeah, so I think I will move on to the next part in terms of the technology and how it can actually help in the audit, right? I mean, as a platform also, we have been helping some of the IAs when it comes to providing information to SEBI, right? And sometimes I think we have a few of these cases where the IA actually don't really know how to answer to SEBI in a way that it doesn't look like they're trying to circumvent the regulations when the information is all there, right? So I wanted to maybe take this opportunity to just go through, what, a platform, not just iFast or any platform, and the technology tools out there in the market, how they can actually help on the audit, and also seek Munish's view, like if those are the things that the auditor will be comfortable with, if it's provided by the platform in the course of the audit. Yeah. So I think due to this pandemic, I think quite a number of advisors have realized the benefits of transforming their business to online, and looking at various areas to see how they can automate and make it easier for them to manage the business. So I guess these are some of the areas that we can see actually helps the advisors to meet the compliance. For example, the client level segregation, the service agreements, right? The KYC fees, risk profiling, the advice and rationale with transactions that Munish has mentioned just now, right? And also client communication and record keeping, right? So how does it actually help? So we can see some of the process and system driven compliance, let's say in terms of the client onboarding, right? There will be a client level segregation based on PAN, which means that if a distribution client has an account on the platform, they should not be able to have a distribution account, right? So if it's an advisory client, it will only be a fee-based and fee charging account, where the products is commission free. So that means there's no regular plan in the account that can be transacted for the client, right? And also the KYC should be or have to be done before the investments or the investment account can be opened, right? That also goes with the risk profiling, which the system will have to help to update every 12 months before the client can transact. If the risk profile has expired, the client should not be able to transact. And also for the agreement, it should be able to e-sign, right? And also the fee structure has to be approved by the client before the whole investment and advice start for the client, right? So in terms of the suitability and advice and record keeping, right, all the transactions of rationale, right, are to be approved by the client before the execution, right? The CRM tool is to record all client communication, of which the client should be able to see the minutes, right, of the call or any meeting that the advisor has done, right? And client approval also on any asset allocation that deviates from the client's risk profile, right? So I guess all the information that the client has in terms of the transaction, the history, the rationale, the advice that is given, and KYC and fee changes should be able to be in one place so that the IA can access this information and provide it for the audit quite easily, right? And last but not least, I guess there was a bit of a details on the fee aspect, on how fees can be charged, right? And how fees can be calculated. So on the platform where, if the fee is calculated based on the daily average AUM, I think that's really actually very fair to the client, so that the AUM itself is done on a daily basis, and of course it's based on the transaction history and the AUM that's given by the client, right? And no fees will be to be charged on the regular AUM. That means the part on the regulation where the distribution agreement has to be excluded from the advisory fee, right? So that's something that the platform should be able to do. And of course, also on the traceability of payment for the fees, all right? And the payment should come from the client's his registered bank account, right? And the new feature where us we look at the automated advance fee and also the fee mode that cannot be changed within 12 months. So I think these are some of the things that technology tools, whether it's the iFast platform or any software in the market, can help, right? So my question to Munish would be, if tools like these are provided, for instance, the meetings and the minutes of the client is recorded in the CRM, and the client had access to the minutes, is that actually enough in terms of doing the record keeping of clients, the interaction?
See, yeah, so I think most of the queries today come to us in these lines, where people tell us whether an SMS would be sufficient as an advice, or how do I document in today's day? There have been a lot of digitized progress in the today's environment, where people give their views, their advices in different formats and in different modes. So question one, to what extent should we document? Your documentation should be enough for a person, I would say from an auditor's perspective. When I want to review a transaction, it should actually speak by itself that what made you come to a conclusion that this is the best script for a particular client. So if that answers my question, then I will be satisfied. And of course, if I'm satisfied, then I would assume that the regulator also would be satisfied, because he would also give an eye from that same perspective. If the CRM platform takes care of all of these parameters, where it records the communication which you are actually doing with the client, you have a space there to keep a note of all the communications which have happened between you and the client, and of course with the log, like it also gives you an awareness of what date did you actually give them this advice, and subsequent to that date there was a deal which was placed for the client. Then I think it should be sufficient documentation from the perspective of your CRM tool which we are talking about. Now whether it is enough, whether that is enough, in that case I would say something which you are uh, uh, able to have, if you are able to have, if you are able to document, we usually keep getting calls, for instance, if there should be some requirement of developing tools where our calls with the customers are being should be recorded. I would say that that is not something which is more important. What is important is keeping a log of what you guys are discussing with your clients, what has been discussed. Like some RAs follow a practice of immediately emailing the minutes of what they have discussed with the client, following up with the calls. So that also would be sufficient, because you are acknowledging the client, at the same time you're also documenting the entire discussion which you have had with the client. So I think what you have just mentioned about this platform enabled for suitably documenting and taking care of all the information with regard to a particular advice which an RIA would give to its client. I think that from an auditor's perspective should suffice.
Okay.
Yeah.
Any view from Rajesh on this? In
I
terms of,
guess-
let's say, whether it's online, it's offline, what are the things that you think that actually, we've done online is fine? Maybe some of the things that is offline is better, or is there even such, division at all?
Well, I guess as we are speaking, we are being relayed a few questions relating to the same client communication and storage, etc. I mean, what I would like to just in general mention is that, you might be communicating in many ways. Maybe a client is calling, you may not be recording all the calls. However, what is important is that before an action is taken, before you confirm on any either changes to a financial plan or a review that is being done, and you're making some adjustments, you're making some allocation decisions, and therefore, you need to document that. Any amount of communication that happens, if you can't store it, at least then there has to be, so again, it's the intent. There has to be a genuine effort to say that these are the minutes of the meeting that we had. Please sign this off as a confirmation of our discussion. Because, sometimes it might be impractical. Maybe a client calls you some late in the night while you are probably heading to your bed, and you can't be expected to, you can't say no to a client if he's a very important client. So I don't think that is what the regulation is trying to say. That regulation is trying to say that so long as you are making sure that you and your clients do not have a difference of opinion when it comes to what you communicated and what he approved. I think life is fine.
Mm-hmm.
But the
Yeah.
moment there is a problem, the moment the client says that, you know what, I was not consulted, or this is an ex-party decision, or this was taken only by the RIA without talking to me, or having any sort of communication with me, then you need to be scuttling, you know, okay, where have I said this? Have I not? And all of that. So we don't want that issue. That is what we are trying to, from an audit perspective, that's what we are trying to address, that we should be able to answer that question if it is raised. So I think let's not get too much into the words, the letters there, but understand what is the spirit behind, what does it mean to say record all forms of communication. That's the generic, you know, suggestion that I would give.
I think I agree with what Raja has said. I think, yeah, you could be talking and saying a lot of things to the client, right? But at the end of the day, what matters is that what did the communication lead to, and what action are you taking, you know, for the portfolios or for the financial planning of the client. So I guess what is important to record is the communication that leads to the action, right? That is the most important. Now, it can come from SMS, it can come from WhatsApp, it can come from any mode of communication, right? And it doesn't matter if, let's say, is not put it in a way that client understood that this is leading to this action, right? So I think there are some questions to Munish as well on this area. Maybe you want to comment on that, you know, if the stand that I'm talking about is valid, or you have another view on that.
Yeah, sorry, Munish, sorry, before you start.
Yeah, sure.
Sorry, Eric, there was one important thing I wanted to mention, at least from experience, is that the most important part on storing, recording, and having communication in place is from the context that it has to be done before, and that is why I was specifying before the action is taken. There are certain cases where, investment advisors have done the action, and then at the end of the day, they have sent an email saying, during the day, these are the actions that I have performed. And please now confirm that you're in agreement. So that is like a post-action consent being taken from the client. Now that should be avoided. At any cost, you should avoid that. So you can't be communicating post-mortem or post-facto. You have to be communicating prior. That's the key word. Yeah. Sorry. Yeah. Sorry, Manish. It was your time. I took it.
No. No, that was a very good point which was made by you, because see, after an act is done, and if you try to document it, backtrail it, then it gets more worse actually. So another thing, what I would want to add here is, as we've been discussing, we should know that we are not doing this documentation only from the regulator's perspective. It is not that only the regulator can question you. Tomorrow, even a client can question you. So you should, of course, be ready, and you of course need to go back and check that there was a consensus of a client before you actually changed a particular risk profile of a client, or there was a consensus of a client to a particular script which was placed. So that is where the documentations would help you. And it is not for the auditors that you are maintaining that documentation. So that has been always a pre-notion which I see, that documentations are just something which the auditors want to have it for storing with them. So we don't actually get happy with increasing our gigabytes. But it is just to ensure, see, from an auditor's perspective, I would want to ensure that if I'm signing off an audit report, I have actually verified, for me, who are the stakeholders. If I'm auditing for an RIA, the main stakeholder for me would be the client, and then it would be the regulator. So tomorrow, even an RIA's client can question me that if you are actually required to audit, and you have audited a particular database, then what did you verify that if there was something which has gone wrong? And the grievance redressal mechanism today has become so transparent. You just need to, it just needs a click of a button for any client to place a complaint, and the action starts. So we should keep that in mind, that documentation is something of your, or I would say RIA's interest, and not an auditor's interest, or maybe a regulator's interest. Yeah.
Yeah, I think I totally agree. And I mean, just to add another point is that I think if there's a system and process to ensure that this process is followed, which means that before any transaction can be approved by the client, there must be a rational input, right?
Yes.
And I mean, that's why you have a system to ensure that you don't miss out on any transaction without any advice or rational. And that shouldn't be done like what Rajesh has said. After it's done, and then you go and send an email and tell the client that this is what we have discussed. But if the client were to turn around and say that, oh, you say that only after I have approved the transaction, and it's not valid, especially if the investments, didn't go as according to plan. But that's why it's important. And also this is back to what Monish has said about the importance of putting in the proper rationale, which I can see sometimes, some advisors just go for the easy way out, which is just put in some one or two words there, and that is the rationale and advice. And when you use a system, that is the audit trail for you and the client, right? So if that document is not done in the proper way, I think if there's any issue in future, that will actually come back and kind of put you in the hot soup, because it seems that you didn't give a proper advice.
Yeah,
right?
I would.
Yeah.
Yeah. Sorry.
Yeah, go ahead. Yeah.
No, I would just like to add a point here. See, as RIAs, I understand that individual RIAs, particularly not the corporate RIAs, but individual RIAs are more of client servicing. So they would want to be involved. Most of their time, they would want to be in client relationships. So of course, they would want to just run away from this administration documentation. But ignoring that completely is something which is not in today's date, which is advisable, because if they're not able to administer, if they're not able to maintain document, they can of course depend upon platforms like iFirst or such platforms, where they have the entire mechanism in place of right from the agreement stage to the log stage to the rationale stage. So just because ignoring today would actually land you up in a problem tomorrow, that would be a situation which I would say should be taken seriously.
And are we also looking at the regulation code going to become more professional, and we are looking at the corporate level kind of corporate governance on individual RIA, and also on new corporate RIA companies who they perhaps used to be from a bank, and they have the support of a financial institution to look at their compliance, to have the system in place and the infrastructure to make sure that they are compliant. And this area is probably new to many of them. When they leave, let's say, a bank and come up to become their own RIA, suddenly they have to grapple with a lot of these issues that they never used to need to look at, because there was somebody else in the bank or with a private bank that helped them to take care of it. So which I feel is actually quite important, right? That they look at it more seriously, and like you rightly said, it's not for the regulator, right? It's not just to please you when you come for the audit. You have everything in place. It's more to really ensure that all the things that you are doing for the client is transparent, and you can meet the standards of good advice, right? Which I think is the whole purpose and intent, right, of the regulations. Okay. I think we can just move on to the other part, which is the informal guidance that we have received as iFast. I think it has been going around in a few of the forums and generated much interest, right? I think one of the things that we saw was very good and very clear from the regulator is that the model of a corporate RIA and a PAIA. Right. So one of the questions that we asked was that if the advisor is not in India and physically not in India, and he wants to advise clients who are Indians who are in India, or who are Indians and NRIs who are not in India, can he actually come under this model, right? And we also have some questions on some forums and advisors about the regulation. Why is it that the regulator is interested in looking at the advisor and not the product where it's from? So for instance, you look at global investment, if it's like in the US, so what is the regulatory aspect that SEBI has when you look at the product in the US, because it's not governed by them, right? So from this perspective, what is your view? Because one is that, do you think the regulator is they look at the product where it's based, or is more on the investor? So I think I start this question with Rajesh.
Okay, so couple of things, I guess. I think from an informal guidance point of view, few things that I just want to make a mention is that there are many cases of informal guidance that have come up in the investment advisory space. We've had guidances that have been requested on claiming reimbursement of expenses from asset managers. Could investment advisors collect fees, performance linked fees? That has been a question that came up. Could you charge brokerage on transactions, because the broking side needs some kind of consideration? Then there were questions around power of attorney. So, and then of course, some of the things that you just mentioned, which you have yourself asked, which you have already covered. But I think one thing that I probably can at least touch upon is there is always a confusion on power of attorney. And maybe I could probably take a minute to speak about that. So the guidance on power of attorney, the informal guidance, or even if we don't consider an informal guidance, let's just look at what it means. So investment advisor taking a power of attorney is what is prohibited. I mean, we have to always see it in the context of the law that we are discussing. We can't be generally saying any POA is not valid in the securities market or cannot be taken. That's not what SEBI is saying. What SEBI is saying is, and what does this power of attorney do? In many cases that they have found, they found that a power of attorney somehow makes the maker the checker and the approver, which is risk, right? I mean, because a client giving a power of attorney to an advisor saying that you are empowered to represent me to confirm on the advice that you give. The whole thing, looks like that, we have some funny characters who come up on the internet who says me talking to me, right? It's like that's what it sounds like, right? So we don't want to be seen as people who are, proposing and disposing at the same time. The profession is not supposed to be seen that way. So what is the spirit behind the power of attorney not being taken by investment advisors is specifically this: that when you advise, don't take the power to approve what you have suggested. Or you have advised. That's the first thing. Second is, do not take a power to take anything which allows you to represent the client and do, even if it were doing it for the client elsewhere. Because that also somewhere tantamounts to saying that, see, you have contracted me as an investment advisor. You are relying on my investment advice, the financial plan that I'm writing for you, and the advice that connects with the plan. And now you give me a power and I will go and do what you need to do elsewhere. Which means, again, it looks a bit like I take a pre-approval and that document is there, and with that I go around and do whatever I need to do, which is also not advisable. So I guess that is the key thing on power of attorney, that, do not touch that. And I guess largely the POA matter would only come in the context of corporates, because I don't think individuals would have any lack of clarity on this. I think it's very straightforward for individuals. It's better that you don't even have this in your lexicon. But for corporates, when you have multiple levels of services to the clients, then for certain segments of your compliances and the exposure that you may have on different markets, for example, in depository services, to debit a client's account, you need the power as a broker. That's different from the POA that we are talking here. Right? So I guess somewhere as an intermediary, we also need to understand what specifically is being said by SEBI. And I guess, there would be a time when maybe our various regulations would move towards not requiring a POA, but, it would more tend towards having that, put together in terms and conditions or agreements. I guess that would be a logical way forward. I mean, that's what I think, because I guess POA is a concept that has been there for long. So maybe over a period of time, these things change. But this is what we need to take care of as investment advisors. Never take a power to approve your own advice. Never take a power to act on behalf of the client, even with a third party. It's better not to do that. Actually, it is prohibited. You can't do it. Yeah.
And I guess if you want to do it, you should get a PMS license then. That's just really good. Manish, so I think we were talking about also, the points on the qualifications, right, and also the 50-year-old, right? So some of the advisors are asking, why is it that there is, the PG is exempted for some advice for the individual advisors only who are 50 years old and above, and not on the PIA, and also not on the principal officer of a corporate RIA, which is a bit strange, right?
Yeah.
I mean, there's no clear answer, and we didn't also get a clear reply as well. I mean,
I'm sure.
Can you view on this?
No, I'm sure even the regulators would not give any clear answer on this. Only so I would not want to comment on, of course, something which is precisely excluded from the scope of the regulations, because if it's not accepted, it is not accepted. We of course we can try to seek further clarification from SEBI regarding this matter and this subject, because since you have raised this point in the informal guidelines, I'm sure we are aware of a couple of further things where we need to seek further guidance from SEBI. I think we should take this up again with SEBI, trying to ask them about why there has been a disparity between these two situations. But considering the past experience, I'm sure we will not land up with any answers unless and until there's a circular which comes in for amending a regulation. Right. Otherwise, till that time, an informal guidelines guidance will never answer your questions on this.
Right.
Yeah.
Okay. And we actually have a question that comes up quite often about the suitability aspect, whether that should be on a portfolio level or the asset allocation level, or should it be looked at the product level or transactional level. Do you guys have a view on this?
Yeah, Eric, should I take that?
Yes.
I guess
you would be the in fact best person to talk about the suitability of a particular product. Yeah.
Yes.
Okay. I guess every time So let me just rewind many years back, and I go back to my Fidelity days. So as an asset manager, when we talk to our portfolio managers, we ask them, how do you pick stocks? So let me talk about a fund, which is, a multi-cap fund. How do you pick stocks? Because every stock, you can go anywhere. You can go large, mid, small. So the research analysts who provide the input to the portfolio manager, they have their recommendations on whether the stock can even make it to your portfolio. Only then the portfolio manager even wants to look at that stock. Otherwise, it's not even in the consideration. The second check that comes in is, does it go with the objective of the scheme? And then the consideration comes in that, okay, if I pick the stock, does it add to concentration in my portfolio, or would it continue to remain diversified the way it is expected to be as per the objective? And then the next is, within concentration, you look at whether it's a sectoral concentration, whether it's a business model concentration, and so many such things. I guess what happens is that a lot of the time, particularly I would encourage the profession to look at risk profiling in a holistic way. By which I mean that individual components may have a risk profile and a matching, which I agree it has to happen, because you need to check things every time there is a conversation. So for example, if I am looking at a client who probably wants to be on the moderate side of conservatism, or I would say, put it differently, moderate side of aggression. So it's slightly aggressive, but largely conservative. Maybe from that perspective, if you look at a specific fund, for example, or a specific stock or an ETF, for example, that individual script may look like it is not matching the risk very clearly, because it looks like, so that is unit level. So I always try to define risk or try to explain that in multiple levels. One is whether at a unit level, are you looking at risk? Okay. The unit level risk check throws a flag. And what is that flag? At the unit level, it doesn't look suitable. But from an investment advisor's point of view, it is a photograph. It is a snapshot of that particular event. That says something is wrong. Be careful. But now you go to the next level, which is the whole video you have created, or the direction of the movie that you have got into, which is the financial planning and the life of the client. There probably you understand that certain amount of the portfolio needs to be exposed to certain asset classes for the long term to achieve certain objectives. And that is within the larger risk profile of the client. So which means at a unit level, while it threw a flag, at a consolidated level, which is at the overall asset allocation level, connection to the plan, connection to the objectives, connection to where this journey is going, it checks. So long as you have that checkbox, I guess in spirit, you're not violating anything. But what you also need to do is that because you have a unit level flag, which is at the point of comparing that particular product to that particular customer's risk profile, because it threw an exception, document that exception. Flag it off saying that at a unit level, it doesn't match. However, I am willing to look at considering this into my portfolio because at the aggregate level, it is fine for me. So that communication from your side and the acceptance from the client, I think I would not see any logical issue in that, because otherwise, how do you generate or create such blended portfolios? You can't, right?
Yes.
That is one important thing. And I also always say that, and this is something that we need to also look at. When we are talking risk, you should also make sure that you are not referring to certain risks that were analyzed sometime in the past. Even if the regulation says review risk every year, risk profile every year. I guess from a financial planning perspective, I always say that the risk profile can change with events. It need not necessarily be the same across the years. It can even change with events within the year. So you could have different changes within the year. So I guess a good assessment of the risk capacity. Does my client have the capacity to take this risk? Or does he have the tolerance to, see the ups and downs? These are so these kind of aspects, the intricate aspects of risk is something that we should make sure we do it, and document it, so that tomorrow when there is a question on just the match of the product, you are able to show a lot more on your understanding of the client's risk profile than what is expected even from a regulatory perspective.
Manish, you have anything to add here?
No, it's such a beautifully explained by Rajesh. Yeah, but rightfully what was explained by Rajesh, that you can't stop a portfolio to be blended when it is actually being accepted by a customer. But of course, flagging it off at the right time is most important. And if the customer has accepted the red flag, if there is any, then in my view also there shouldn't be a problem, because the customer has concurred to the view of the advisor, and that is before the execution of the advice, so that should be fine.
Right. So if let's say the client's risk profile is conservative and the recommended asset allocation is 80-20, right? So there's the 20% in equity. And then they recommend a product, let's say a mutual fund stock that's considered high risk, right? So will that be fine? And if it's fine, then what else should they add on to the transaction?
So, so two things, first is, like I said, it's a unit level risk question, which you just mentioned, right? And at the unit level, yes, there could be a problem. It could flag off, which is also there in the mutual fund regulations. While we are not mixing regulations, but I'm saying even there is an expectation that if it doesn't suit, then you need to make a note that it is with the specific consent that it doesn't suit. And again, I saw a question there in the chat box that can I take that as a proof? No, mutual fund regulations are separate. Even if you have documented it there, you need to document it for investment advice. So you need to replicate it. You need to have it in the records of your investment advice related client interactions. So you need to incorporate that there. But I mean, just to make it lighter, because I know it's a heavy topic, but just to, I mean, I always fondly remember all the cartoons that we have watched of Tom and Jerry. We can never forget, right? It's one chasing the other, one chasing the other, one beating the other beating the other, right? So even in risk, I keep talking about Tom and Jerry to some of my friends who are classmates and with whom I can afford to joke, but I guess I could use that today. I say that, it's a cat and mouse game. And in the cat and mouse, I always specify CAT in capitals, which I just mentioned. When you look at client risk, think of the cat, which is the risk capacity, the risk appetite, and the risk tolerance. And each of this has to be evaluated before you get to a point where you say, I understand the client's risk profile. And then you could answer, much more authentic, and you could be much more confident, even if a regulator grills you, saying that, give me the evidence, this doesn't look suitable. So you understand capacity, you understand the appetite, you understand the tolerance, then you know the profile, then you do what you have to do, which suits the profile and the plan and the objective. I don't think there's going to be a problem.
Okay, I think we have already started to look at some of the questions from the audience, right? So we can, I think, take a few more of this, right? So I have one of the questions, I think this is for Munish, right? How will the compliance change if the RIA provides the services like research reports to the client, which are generic in nature and do not require any face-to-face interaction with the client? Is there any change?
I'm sorry, I did not get that question right.
Okay, so how will the compliance change if the RIA provides the services like only a research reports, which is generic in nature, and also does not require any face-to-face interaction with the client? Is there any change? Does it still need to meet?
No. Since no. So what I feel where this is coming from is online advising to the client without facing them. So you can't advise before you understand the risk, do the risk assessment of a particular client. So this I think in essence is against the requirements of the regulation. So the most important part of assessing the client's risk is being missed out here. So I would not say this is advisable.
Okay, so that means anybody who gives advice, even if it's not tailor-made for any particular client, right, still have to comply with the regulations, the IA regulations.
Yes. So friend-to-friend talk is something different. But when you actually are documenting an advice without even knowing a client, then that would somewhere land you into trouble.
Okay. We have another question about can the RIA services that is not being charged, I mean, no fees are charged, right? But with the full compliance on the signed agreement and risk compliance act, all that is done, can that services for the RIA be offered, right, when the fees are not charged?
Okay, maybe I can go.
Yeah.
Couple of things. There's a background to this as well. Many a time, what we have seen, and I would encourage you whoever asked this question to also go into the SEBI website and search for the interim orders of SEBI, not the final orders, the interim orders, because final orders are awaited. Interim orders of SEBI also show you what are some of the things that the RIAs are doing which they are not liking, which they feel it's not compliant, and therefore they are chasing them up on non-compliance. Right? That gives you an idea where are the mistakes. And many a time it comes up when clients start complaining, and that's probably the genesis of a lot of the things that the regulator does do. When the clients complain, there's no way but to go to the root of it and find out what's going wrong. There has been consistent exploitation by offering certain freebies to the clients and luring them to take up the services and then later fleecing them. That's there. Unfortunately for us, in some of the interim orders, you could see that. So I would say that it is not specific in the regulation that you cannot offer something free, but that's not the regulator to dictate whether you can or you cannot. It is basically a business decision, right? What do you want to charge your client is a business decision within a cap. But what I'm trying to highlight here is that free is often not the great thing to pursue, especially in a relationship like this. There are various ways, in fact, what does the regulation say? They say the regulation gives us two ways to look at fees. One is the fixed fee model, the other is the percentage-based model. Now, in a fixed fee model, you can always have an invoice generation at the end of the quarter. And if before the end of the quarter, the client says, you know what, I did experience your services, but I'm not happy. And you have a prorated invoice for the client, but you say that, because you said you are not happy, I'm not taking any money from you. That's my decision not to charge you because you're not happy with me. And here's the documentation. Here is your prorated invoice. Here's your credit note. For example, I'm not saying you should do it, but I'm just generally thinking aloud as an example. It could be as good as what you're trying to achieve. That is, what are you trying to achieve? You're trying to achieve comfort of a client before the client signs up for eternity with you, which is what you want. You want a client to be there forever. That's how every financial planner wants to approach a client. If that is the case, then the starting point is, okay, if I charge and I don't deliver, then it doesn't look good. That's the spirit behind that question I am looking at, If that's the case, then how do you solve for it? I guess there are ways in which you can solve for it. You can decide that, okay, you will write the plan. If you don't like the plan, you're going to rubbish this plan and put it in the trash. I'm not going to charge you. But you have agreed with the client that the client will pay you on submission of the plan. But you say that, okay, you are going to trash the entire thing because you say this, and this that I have written is completely, out of sync with what the client wants. And therefore, the client doesn't want to proceed with you. You document that and you say, because of this, I did not charge the client. Is the regulator going to come back and say, no, you have to charge the client? I guess, so it's how it gets used, Eric, and unfortunately, I would say the misuse is rampant. And that is why maybe, we have to be even more careful before we start saying, experience me for free, and then you decide, that's probably not a great thing.
I think that's really a great point. I think it always points back to the intent, right? And the
Yes,
spirit
intent.
And what are you trying to achieve here, right? And the regulation is not going to give you each and everything to tell you the do's and don'ts. You can do this, you cannot do that. That is not what the regulation is supposed to do, because there'll be many ways that people are trying to circumvent it. Oh, you said this, so therefore I can do that, right? So yeah, I think it really boils down back to what are you trying to achieve with this action or with this pricing or with anything that you're trying to do with the client. And if there's something that is like you feel you need to explain further and make sure the client is also clear of what you're trying to achieve, then that should be coming back to the documentation aspect. It should be done there so that it's crystal clear why this action is taken in the first place.
And I guess there again, everybody has to be careful because, at the end of the day, time is what is your only resource.
Yes.
As financial planners, time is your biggest resource. And if you decide to go this way, which is again your own decision, you might end up spending that valuable resource and not taking care of your own personal finances, right? I mean, and if you have that, I would always say, have the confidence that, you are going to go and give what you honestly want to give to the client. And if they're not satisfied, don't just walk away saying that, I don't want anything, because you've spent that effort to do it. You've genuinely spent it, So it's always, again, a very, very individual personal decision. It could work both ways, but there is no single prescription. But I would definitely say, stay away from free. That's not the way to go.
Yeah, so I will take one question again. This time is for Munish. All right, there's a question about if an RIA ties up with a platform, right, be it iFiles or another platform, right? So is the client the client of the platform, right? Who is responsible for the compliance, right? And what are the implications for risk profiling and risk management?
So basically, what I understand, the person who has raised this query is trying to understand the bifurcation between the responsibility of the platform if they are trying to avail the services of a platform, the advisor, and who will be answerable to the client. The answer to this question, of course, would remain that at the end of the day, the client is entering into an agreement with the advisor. So the advisor is ultimately responsible for the advices which it gives, the services which it is supposed to render, be it to the client or be it to the regulator. Availing the services of a platform is for the convenience of the RIA. It will not move you away from the responsibilities which the regulators are charging on the RIAs, because you have the license under your name, so the ultimate responsibility and ownership is yours. Of course, there would be a level of ownership with which the platform, they take it on their on their head. That is primarily to maintain the relationship between the platform and the RIA. But when it comes to answering to any regulator or any compliance or non-compliance, it's the responsibility of the advisor to make sure. So that is where we usually recommend that if you want to choose a platform, you need to verify end to end what are the facilities a platform is actually offering you, whether it's covering all the compliances, whether it is being upgraded on a daily basis. In today's date, as you've seen, BASL has recently been introduced as a body. We can expect that in every 3 to 4 months, we will find some new actions which will be introduced by BSL, because they have yet not come out how we are supposed to report regularly to BSL. So they will come out with even that could actually add on more responsibilities. So RIA needs to ensure with the advisor, with the platform, and get a comfort there that whether the platform is well versed, they have a set of team who is updating the platform with the required compliances on a routine basis. But at the end of the day, the RIA is answerable to all the questions and the responsibilities.
Okay. Anything to add from Rajesh?
Yeah, I mean, I guess Manish has covered pretty much all of it. One addition that I could say is from experience is that whenever there has been an audit, I have noticed that SEBI would expect the license holder to completely own all processes, all tools, and everything that you put in place to engage with the client. In the sense that, for example, we just spoke about Tom and Jerry, the risk assessment. Suppose you are evaluating the risk profile of a client using a tool. And I mean, I would say, how do you define whether the tool that you have, or even if you created 20 questions, would you be able to analyze risk well? You might not have enough evidence to prove that. But some people would decide, okay, let me not get into that. Let me use somebody's services to do the risk profiling. I have noted in some cases where the regulator expects that, as an investment advisor, you have to own up that this risk profiling is satisfactory to you first. And so you own up to the risk profiling that is thrown out from the system. You cannot say, I am absolved of that risk profiling given by that system, because that's not me, that's a system. So you have to own up. That's the key word. You have to own up. You can use any system, any platform, any software. You could generate your own Excel tools, macros, whatever. But at the end of the day, you have to own up. If you are the license holder, that's the input.
Okay, thank you very much. So I think we just take last two questions from the floor, and I will advise those questions that is more specific to your individual cases, or more specific to IFAS itself, right? You can come directly to us, or you can go to your CA, or you can even engage Munish as your CA, right, to answer those questions that relate very specifically to your business. Because I think this is actually not a forum to answer like business-related kind of questions, right? So and everything is all based on the context that we look at, right? So let's take two more questions. I think one will be, what are the penalties prescribed for non-compliance right now? Has there been anything that has been announced yet?
So there's a saying, this reminds me of that saying actually, that if you think compliances are expensive, try non-compliances. So to answer this question, no, there are no specific act-based penalties which have been prescribed. As I earlier mentioned, if SEBI as a regulator observes that there are anything which is not being complied with as per the regulations, then they have their own mechanisms and they have their own parameters to decide what penalty they would charge to a particular advisor. And the most important, as I earlier mentioned, and also as Rajesh rightly mentioned, that the intent is most important here while deciding a penalty by the regulator.
Okay. Anything from Rajesh's side? Is there anything that we don't know about that you can share?
No, I was just looking at the risk element, and I always never miss a chance to say, that everybody who is an intermediary must have professional indemnity. And particularly, you also have to note that professional indemnity insurance doesn't cover if you have consciously made or if you have consciously broken law. It doesn't cover you from, so you can't take professional indemnity and go jailbreaking.
That's actually a very good point, but some people do think that, oh, I'm well protected. So it's like, if I had taken 2 jabs, let me just remove my mask and just go everywhere without looking at this now.
Yeah. So it's still, I would say professional indemnity is still like, your 2 doses of COVID vaccine. You're still supposed to follow social distancing. You're supposed to wear a mask and disinfect.
That's a very nice example, actually.
Yeah. So I guess we will just take one last question. I think there's one question that asks about the fees to the accredited investor beyond what is prescribed under the regulation. Can they actually charge fees now, or is there any change right now?
Sorry.
Okay, so can they charge fees to the accredited investor beyond what is prescribed under the RIA regulations now?
No, so RIA has prescribed the maximum limit 1.25 or 2.5%, whichever they choose to be fined, and they are specific. They have been really clear on that note that this is the maximum limit which is prescribed, not beyond this.
Okay.
So am I answering the question rightly?
Yes, yes. I think there are some questions because the new category of investors, right? And I think some are asking whether there is a different fee level that they can charge for this new category of investor. Okay. I think right now I don't think there's clarity on that yet.
Okay.
Yeah, I mean, I would always say that if it is, so if you are talking in the context of investment advice and investment advisory regulations, then very clearly everything related to fees is 15A. And any change to 15A should, if it incorporates any such changes, like 15A fixed fee, 15A, you have the AUA based fee.
Yeah.
In that, if they say that there is an exception for accredited investors, for example, then this might hold good. And what that exception is, maybe if it is defined again, then you could go there. But until such time, like Manish said, until such time that the regulation isn't changing, just because there is an investor category, I don't think automatically checks the box on changes here.
So what we need to concentrate here on your role as an advisor, not as another class of investor being introduced here. So,
okay. Okay, so I guess we can wrap this up, and really thank you very much for spending the time with us. Right,
thank you so
questions.
much.
Thank you, Rajesh, and thank you, Monish.
Thank you, Eric. Thank you,
for
Rajesh.
coming to this webinar, and have a good evening.
Thank you. Have a good evening. Bye.
Yeah, all of you. Bye bye. Take care.
Bye. Take care.